May it please the court, my name is David Townsend and I represent the Appellant Design Concept Italia, Inc. In this case...
Counsel, would you like to reserve any time for your rebuttal?
5 minutes.
Excellent.
Thank you. In this case, my client was asked to prepare drawings for redesign of the kitchen. He did so, he spent 3 months on it, and the drawings were approved, they were all signed off on, and the appellee ended up using the drawings. The dispute, the essence of the dispute is what my client's consideration was. He claims that there was an agreement for him to be paid $225 an hour, and the appellee denies that. Affidavits supporting those two positions were filed, and the court basically threw out my client's affidavit and accepted the appellee's affidavit. In addition, the court relied upon evidence that was not in the record. The references to Mr. Ogle were all inappropriate, and the court also overruled an objection to irrelevant evidence having to do with the written contract that was later submitted and denied. That's not an issue. The appellee was certainly had no obligation to sign that contract if they did not to for whatever reason. So our position is that the judge did not follow the summary judgment rule because he basically refused to consider the opposing evidence, the affidavit that my client filed.
Well, counsel for appellee is going to probably stand up and talk about cases that allow for summary judgment when the party opposing it is relying on what is going to be characterized as a self-serving affidavit.
Well,
by no other evidence.
If my client's affidavit falls in the category of self-serving, so does the appellee's affidavit. Basically, she says, no, there wasn't an agreement. My client says there was. And if my client's affidavit is self-serving, so is hers. They should have equal probative value.
Well, if crediting, you made a statement earlier about the $225 per hour. Even if we credit that evidence, taking everything, all inferences in favor of your client, is that enough to get over the hurdle of the absence of any really evidence that it was a contract for discreetly for design services independent of a contract for the actual construction? In other words, you said that seems like a fulcrum point. If we credit the affidavit that he said that the parties agreed that there would be a $225 hourly rate, is that the end of the story? Does that prevent summary judgment? If summary judgment's based on the fact that there was no contract merely just for design services, it was a package deal.
Well, I mean, obviously there was a contract. He did the work. I mean, they had some sort of an agreement. He did the work. They approved it and they used it. The only missing element is how he was to get paid. He says that there was an agreement for an hourly rate. She said, no, there wasn't. But, you know, if it's a question of believability, this was an attorney on the other side. And are we supposed to believe that she never discussed how he would be paid for the work that he did? That's not plausible. And
well, there was discussion about lump sum, right? I mean, $68,000.
No, sir, I don't believe there was. I mean, my client took the position that he was anticipating being paid at an hourly rate. And the appellee denies it. And so you've got a classic conflict of facts. That's, unless you have further questions, that's my argument, Your Honor.
Okay, you'll have 5 minutes for rebuttal.
Okay, thank you.
Good morning, Your Honors. May it please the court. My name is Whitney Ray DeBona, and I represent myself and my husband Garrett DeBona in this appeal. What this case boils down to is essentially a lien by ambush. Florida's lien law is clear that a lien cannot be valid without a contract to support it. And there is nothing in the lower court record that proves or could prove that a contract was entered into between myself and Design Concept Italia, or DCI, and the court properly ruled that there was no genuine dispute of fact such that a jury could return a verdict in favor of the plaintiff. On appeal, DCI makes one argument, that the lower court erred because it considered my affidavit that was attached to the summary judgment motion as being more probative in value than the affidavit attached by Mr. Cohen on behalf of Design Concept Italia. But we don't even need to reach that issue, because what DCI fails to address is the fact that the lower court said there was no contract because Mr. Cohen represented himself as having a different name and representing a different corporation than the corporation that ultimately put the lien on the property. And for that reason, no valid contract could have been entered into, and the underlying lien is invalid. The undisputed record evidence shows that when I first met Mr. Cohen on January 2nd of 2022, he said that his name was Gianni Pirelli, and he told me that the company he was representing was Venetian Interior Design Corp. He sent me emails with a company email address from Venetian Interior Design Corp. They represented that he had a store at International Mall. They showed me photographs of prior kitchens and prior work that Venetian Interior had performed on a website from Venetian Interior Design Corp. And none of this evidence is disputed by the plaintiff. I was under the impression that if we decided to move forward and ultimately sign a contract with this company, it was Venetian Interior Design Corp that we would be working with. So after 2 months go by and I continue to ask for a final price and a contract to review, I'm finally sent a written contract March 18th of 2022. And the name on that contract is Design Concept Italia, which is a company that I have never heard of. I have no idea who this company is. So that's when I went online and I started researching and trying to figure out who is this company. I find out that it's registered to...
Counsel, we're apprised of the facts, but, you know, can you get to the legal issue, the legal issues?
Yes, Your Honor. I mean, the basic legal issue is you can't enter... Contracts 101 is you have to agree to the material elements of the contract. Everyone has to understand what you're contracting to. And the most basic element of that is who are the parties to the contract. You can't enter into a contract with a party that you don't even know exists.
Is your argument that even if there might be some material fact dispute about whether there could have been a contract between Mr. Pirelli or Cohen regarding an hourly rate for design, the lien holder is Design Concepts, with whom there is no dispute of fact about whether you entered into a contract?
Yes, Your Honor. That is the argument.
Because I was going to ask you about your assertion that this was a self-serving affidavit in the sense that, for instance, the rich fee are wrong. I think that was what you all asserted as a support. Isn't there a difference? In other words, in that case, there was that affiant was contradicting his own other documentary evidence. We don't have that scenario here, correct? You know, whether or not there was a discussion or an agreement with, according to Mr. Pirelli or Cohen, whatever his name he goes by, that's not contradicting any other evidence that he submitted. Is that true?
That's true, Your Honor. And, you know, even if the court looked at the affidavit issue and considered the self-serving affidavit argument, Again, the problem is that Design Concept Italia says there was an oral contract entered into on January 2nd, 2022, when they were still representing themselves to me that they were a different company. So, you know, as I said earlier, we don't even really need to get to the affidavit issue because there couldn't have been a contract entered into, an oral contract on January 2nd, when there's undisputed evidence that Mr. Cohen told me the company was Venetian Interior Design Corp. So even assuming that the court said there's a genuine issue of fact and, you know, there's a dispute in the evidence, there's no dispute that the contract would have been entered into with Venetian Interior Design Corp, and that's not the company that put the lien on the property. And again, the trial court, you know, made it very clear that one of the reasons why, really the main reason why he granted the motion for summary judgment, he said there can be no mutual assent where a party misrepresents his identity and then claims that a counterparty entered into an oral contract with a previously unidentified corporation. And then just to briefly address again the affidavit issue, the standard is whether there is record evidence such that a reasonable jury could return a verdict in favor of the non-moving party. And the Rich case that the trial court cited in its order points out that any evidence that is merely colorable or is not significantly probative will not overcome the burden. And the trial court pointed out that Mr. Cohen's affidavit was not probative in light of all of the other record evidence. I mean, we attached months of correspondence, other documents. There was a ton of other evidence. Nowhere in any of that was there any reference to an agreement to pay $225 an hour for any design service. That's just nowhere in the record. And so again, that was one of the reasons that the trial court, you know, he pointed out, he wasn't just relying on the affidavits, you know, by themselves. He was looking at all of the other evidence in the record, and that's why he came to the conclusion that Mr. Cohen's affidavit was merely colorable. It didn't add any probative value, and it didn't provide evidence that a jury could look at and return a verdict in favor of the plaintiff. So for all of those reasons, the trial court's decision should be affirmed. And unless you have any more questions, that's all I have. Thank you.
Two matters. One, the vast majority of the evidence that counsel refers to had to do with the second contract, which they decided not to sign for whatever reason, but it doesn't have any bearing on.
Was that with the lien holder? Was that second contract with the lien holder?
Well, he submitted a contract to go ahead and perform the changes to the kitchen, and they did not want to sign it. But that contract was done after he had concluded the preparation of the drawings. And there were two separate events.
Now, I mean, there's evidence in the record that the preparation of the drawings was at least part of an alleged contract that included both the build and the design, right? You would agree that some judgment evidence supports that?
Well, there was an agreement.
But you're alleging that there's also a separate agreement for a hourly rate contract for design only.
Yes, sir. I'm sorry.
So would you agree that there's summary judgment evidence to support that there were negotiations, you know, in other words, I'm not trying to credit either side here, but there were negotiations that were leading to what would have been a contract for both design and build, right?
What I would agree to is that the parties did agree that if they ultimately signed the contract to do the improvements, that he would include in there his services for doing the drawings. But then that never happened.
Right, that never happened, and your argument relies on a separate contract,
Yes.
a design-only contract that was purportedly entered into with the parties.
And all of the elements of the
And
contract.
was that separate contract one that, one of the parties, the actual lien holder?
Yes, yes.
Who's the lien holder?
The
Design Concept Italia?
Italia, yes.
So that you think the summary judgment evidence is such that a jury could find in favor, according to the affidavit, that by having conversations about an hourly rate with Mr. Cohen, that formed a contract with Design Concept Italia for an hourly rate for just design only? For
If the
design
jury were given the testimony by one party that we had an agreement, we performed the contract and you got the benefit of it, and we had an agreement as how to be paid. And the other side, no, we didn't have an agreement as to that element of the contract, the jury could rule in our favor. And one last thing, counsel refers to all of this plethora of evidence that didn't refer to an hourly rate. It didn't address the issue at all of what he was to be paid, the evidence that they're submitting. And there's some responsibility on the part of the other party to address that issue. Why in their communication was it they didn't raise that issue? So I submit that the court erred by admitting evidence that it should not have admitted and by having disregarded the appellant's affidavit. Thank you.
This case is Friedman versus 919 Old.
May it please the court, my name is David Townsend and I represent the Appellant Design Concept Italia, Inc. In this case...
Counsel, would you like to reserve any time for your rebuttal?
5 minutes.
Excellent.
Thank you. In this case, my client was asked to prepare drawings for a redesign of a kitchen. He did so, he spent 3 months on it, and the drawings were approved, they were all signed off on, and the appellee ended up using the drawings. The dispute, the essence of the dispute is what my client's consideration was. He claims that there was an agreement for him to be paid $225 an hour, and the appellee denies that. Affidavits supporting those two positions were filed, and the court basically threw out my client's affidavit and accepted the appellee's affidavit. In addition, the court relied upon evidence that was not in the record. The references to Mr. Ogle were all inappropriate, and the court also overruled an objection to irrelevant evidence having to do with the written contract that was later submitted and denied. That's not an issue. The appellee would certainly had no obligation to sign that contract if they did not to for whatever reason. So our position is that the judge did not follow the summary judgment rule because he basically refused to consider the opposing evidence. the affidavit that my client filed.
Well, counsel for Appellate is going to probably stand up and talk about cases that allow for summary judgment when the party opposing it is relying on what is going to be characterized as a self-serving affidavit.
Well,
by no other evidence.
If my client's affidavit falls in the category of self-serving, so does the Appellee's affidavit. Basically, she says, no, there wasn't an agreement. My client says there was. And if my client's affidavit is self-serving, so is hers. They should have equal probative value.
Well, if crediting, you had made a statement earlier about the $225 per hour. Even if we credit that evidence, you know, taking everything, all inferences in favor of your client, is that enough to get over the hurdle of the absence of any really evidence that it was a contract for discreetly for design services independent of a contract for the actual construction? In other words, you said that seems like a fulcrum point. If we credit the affidavit that he said that the parties agreed that there would be a $225 hourly rate, is that the end of the story? Does that prevent summary judgment? If summary judgment's based on the fact that there was no contract merely just for design services, it was a package deal.
Well, I mean, obviously there was a contract. He did the work. I mean, they had some sort of an agreement. He did the work. They approved it and they used it. The only missing element is how he was to get paid. He says that there was an agreement for an hourly rate. She said, no, there wasn't. But, you know, if it's a question of believability, this was an attorney on the other side. And are we supposed to believe that she never discussed how he would be paid for the work that he did? That's not plausible. And
well, there was discussion about lump sum, right? I mean, 68,000.
no, sir, I don't believe there was. I mean, my client took the position that he was anticipating being paid at an hourly rate. And the appellee denies it. And so you've got a classic conflict of facts. Unless you have further questions, that's my argument, Your Honor.
Okay, you'll have 5 minutes for a vote.
Okay, thank you.
Good morning, Your Honors. May it please the court. My name is Whitney Ray DeBona, and I represent myself and my husband, Garrett DeBona, in this appeal. What this case boils down to is essentially a lien by ambush. Florida's lien law is clear that a lien cannot be valid without a contract to support it. And there is nothing in the lower court record that proves or could prove that a contract was entered into between myself and Design Concept Italia, or DCI, and the court properly ruled that there was no genuine dispute of fact such that a jury could return a verdict in favor of the plaintiff. On appeal, DCI makes one argument, that the lower court erred because it considered my affidavit that was attached to the summary judgment motion as being more probative in value than the affidavit attached by Mr. Cohen on behalf of Design Concept Italia. But we don't even need to reach that issue, because what DCI fails to address is the fact that the lower court said there was no contract because Mr. Cohen represented himself as having a different name and representing a different corporation than the corporation that ultimately put the lien on the property. And for that reason, no valid contract could have been entered into, and the underlying lien is invalid. The undisputed record evidence shows that when I first met Mr. Cohen on January 2nd of 2022, he said that his name was Gianni Pirelli, And he told me that the company he was representing was Venetian Interior Design Corp. He sent me emails with a company email address from Venetian Interior Design Corp. They represented that he had a store at International Mall. They showed me photographs of prior kitchens and prior work that Venetian Interior had performed on a website from Venetian Interior Design Corp. And none of this evidence is disputed by the plaintiff. I was under the impression that if we decided to move forward and ultimately sign a contract with this company, it was Venetian Interior Design Corp that we would be working with. So after 2 months go by and I continue to ask for a final price and a contract to review, I'm finally sent a written contract March 18th of 2022. And the name on that contract is Design Concept Italia, which is a company that I have never heard of. I have no idea who this company is. So that's when I went online and I started researching and trying to figure out who is this company. I find out that it's registered to...
Counsel, we're apprised of the facts, but, you know, can you get to the legal issue, the legal issues?
Yes, Your Honor. I mean, the basic legal issue is you can't enter, contracts 101 is you have to agree to the material elements of the contract. Everyone has to understand what you're contracting to. And the most basic element of that is who are the parties to the contract. You can't enter into a contract with a party that you don't even know exists.
Is your argument that even if there might be some material fact dispute about whether there could have been a contract between Mr. Pirelli or Cohen regarding an hourly rate for design, the lien holder is Design Concepts, with whom there is no dispute of fact about whether you entered into a contract?
Yes, Your Honor. That is the argument.
I was going to ask you about your assertion that this was a self-serving affidavit in the sense that, for instance, the rich fee are wrong. I think that was what you all asserted as a support. Isn't there a difference? In other words, in that case, there was that affiant was contradicting his own other documentary evidence. We don't have that scenario here, correct? You know, whether or not there was a discussion or an agreement with, according to Mr. Pirelli or Cohen, whatever his name he goes by, that's not contradicting any other evidence that he submitted. Is that true?
That's true, Your Honor. And, you know, even if the court looked at the affidavit issue and considered the self-serving affidavit argument, again, the problem is that Design Concept Italia says there was an oral contract entered into on January 2nd, 2022, when they were still representing themselves to me that they were a different company. So, you know, as I said earlier, we don't even really need to get to the affidavit issue because there couldn't have been a contract entered into, an oral contract on January 2nd, when there's undisputed evidence that Mr. Cohen told me the company was Venetian Interior Design Corp. So even assuming that the court said there's a genuine issue of fact and, you know, there's a dispute in the evidence, there's no dispute that the contract would have been entered into with Venetian Interior Design Corp, and that's not the company that put the lien on the property. And again, the trial court, you know, made it very clear that one of the reasons why, really the main reason why he granted the motion for summary judgment, he said there can be no mutual assent where a party misrepresents his identity and then claims that a counterparty entered into an oral contract with a previously unidentified corporation. And then just to briefly address again the affidavit issue, the standard is whether there is record evidence such that a reasonable jury could return a verdict in favor of the non-moving party. And the Rich case that the trial court cited in its order points out that any evidence that is merely colorable or is not significantly probative will not overcome the burden. And And the trial court pointed out that Mr. Cohen's affidavit was not probative in light of all of the other record evidence. I mean, we attached months of correspondence, other documents. There was a ton of other evidence. Nowhere in any of that was there any reference to an agreement to pay $225 an hour for any design service. That's just nowhere in the record. And so again, that was one of the reasons that the trial court, he pointed out, he wasn't just relying on the affidavits, by themselves. He was looking at all of the other evidence in the record, and that's why he came to the conclusion that Mr. Cohen's affidavit was merely colorable. It didn't add any probative value, and it didn't provide evidence that a jury could look at and return a verdict in favor of the plaintiff. So for all of those reasons, the trial court's decision should be affirmed. And unless you have any more questions, that's all I have. Thank you.
Two matters. One, the vast majority of the evidence that counsel refers to had to do with the second contract, which they decided not to sign for whatever reason, but it doesn't have any bearing on.
Was that with the lien holder? Was that second contract with the lien holder?
Well, he submitted a contract to go ahead and perform the changes to the kitchen, and they did not want to sign it. But that contract was done after he had concluded the preparation of the drawings. There were two separate events.
Now, there's evidence in the record that the preparation of the drawings was at least part of an alleged contract that included both the build and the design, right? You would agree that some judgment evidence supports that?
Well, there was an agreement.
But you're alleging that there's also a separate agreement for a hourly rate contract for design only.
Yes, sir. I'm sorry.
So would you agree that there's summary judgment evidence to support that there were negotiations, in other words, I'm not trying to credit either side here, but there were negotiations that were leading to what would have been a contract for both design and build, right?
What I would agree to is that the parties did agree that if they ultimately signed the contract to do the improvements, that he would include in there his services for doing the drawings. But then that never happened.
Right, that never happened, and your argument relies on a separate contract.
Yes.
A design-only contract that was purportedly entered into with the parties.
And all of the elements of the
And
contract.
was that separate contract one that one of the parties, the actual lien holder?
Yes, yes.
Who's the lien holder?
The
Design Concept Italia?
Italia, yes.
So that you think the summary judgment evidence is such that a jury could find in favor, according to the affidavit, that by having conversations about an hourly rate with Mr. Cohen, that formed a contract with Design Concept Italia for an hourly rate for just design only? For
If
design
the jury were given the testimony by one party that we had an agreement, we performed the contract and you got the benefit of it, and we had an agreement as how to be paid, and the other side, no, we didn't have an agreement as to that element of the contract, the jury could rule in our favor. And one last thing, counsel refers to all of this plethora of evidence that didn't refer to an hourly rate. It didn't address the issue at all of what he was to be paid, the evidence that they're submitting. And there's some responsibility on the part of the other party to address that issue. Why in their communication was it they didn't raise that issue? So I submit that the court erred by admitting evidence that it should not have admitted, and by having disregarded the appellant's affidavit. Thank you.
This case is Friedman versus 919 Old